Hi, everyone. Thank you so much for joining us. My name is Naz Modirzadeh, and I am the director of the program on international law and armed conflict here at Harvard Law School. And we are incredibly thrilled to be joined by Dr. Gloria Gaggioli for a discussion on self-defense in armed conflicts. I'm just going to give a few introductory remarks, a few administrative remarks, and then introduce our speaker and hand the floor over to her and suggest that we get going so that we have plenty of time for questions and answers. By way of introduction, I know most of the people in this room are very familiar with the many debates and legal questions surrounding the relationship between claims of self-defense and both the use ad bellum and the use in bello, the law applicable to the initiation of the use of force, and the law applicable in situations of armed conflict. The question of self-defense has been in the news quite a bit, even over the past week, as we have seen discussions that, for example, it appears that the U.S.'s approach to the classification of the al-Shabaab group in Somalia has changed from one that appeared to be rooted in engagements based only in self-defense to a classification of al-Shabaab as an associated force of al-Qaeda and other organizations. So I think it's a particularly timely discussion, and I think efforts to illuminate the role of international law and the scope of international law in these debates are really worthwhile and contribute to not only our understanding, but our development of debates and policy solutions to the problems that many countries face in this area around the world. A few administrative remarks. First, this is being recorded, so please be aware of that. We are recording the entire 1.5 hour session, so both the presentation and the questions and answers. I would ask you to silence your cell phone so that we don't have a disruption of the recording. And we will have about 30 to 40 minutes for the presentation, and then we'll open up the floor for questions, comments, and engagement with the speaker. So hopefully we'll have an opportunity for a lively exchange after the presentation. And now, if you allow me, I'll give a few introductory remarks for those of you who are not familiar with our speaker and hand over the floor. Dr. Gloria Gaggioli is Grant Holder of Excellence, one of my favorite titles of all time, I must say, and Assistant Professor at the University of Geneva, and presently Stockton Distinguished Scholar in Residence at the U.S. Naval War College, where we're really delighted. Our PLAC fellow, Professor Mike Schmidt, is, of course, at the Stockton Center, and we're always excited when we get to collaborate formally and informally with the Naval War College Stockton Center. She's an international lawyer specialized in IHL and human rights law with more than 10 years of academic and practical experience. She has researched and taught in several universities in Europe, in Switzerland, France, Denmark, and Sweden, and in the U.S., and has worked as a legal advisor at the International Committee of the Red Cross. Her publications have focused most notably on the interplay between human rights law and humanitarian law, the right to life, and use of force issues. And we're really thrilled to have you.
Thank you very much. So thank you very much, Professor Modirzadeh. I'm very, very honored to be here with you today to talk about this research project on which I'm working now, that is self-defense in armed conflict situations. I would like also to really warmly thank Dustin for having organized this event. I'm really grateful for that. And I would like also to thank the University of Geneva for financing my research projects, and the Stockton Center for the Studies of International Law, which has welcomed me during the last 3 months as a visiting scholar. So when we talk about self-defense in armed conflict situations, the first thing we can say is that many people will use this concept in very different ways. So a first issue I would like to discuss with you is the practice. Who, when, and how different stakeholders will be talking about self-defense in armed conflict situation. I would say that there is a real use and misuse of the concept of self-defense in military operations today. Then we will see how this concept is a multifaceted concept. It has various legal sources. I will then dig into the threats and opportunities related to this new concept of self-defense introduced in armed conflict situations, and finish with some recommendations as take-home messages. So let's start with the use and misuse of self-defense in military operations. looking at the practice, we can see various stakeholders talking about self-defense. First, regarding states. States refer to self-defense not only in a use ad bellum terminology, not only to explain why they are going to resort to force, but also to explain targeting rules, how they conduct hostilities in an armed conflict situation. I think the practice regarding the US on drone strikes, regarding worldwide counterterrorism operations is one very good example of this phenomenon. But also in military spheres, you can see that the concept of self-defense is very much used by the military. Take, for instance, the San Remo Handbook on Rules of Engagement, dated 2009. Rules of engagement are used by the militaries, by even individual soldiers in the field in order to know how they should behave in an armed conflict situation. When you look at the San Remo manual, what was really striking to me is that there is a lot about self-defense in those rules of engagement. You can even look at the attached card to this handbook, and you see that the card related to armed conflicts, this little small card, which is given to soldiers when they go into the field to conduct military operations in armed conflicts, is mostly dedicated to self-defense. So you see 2/3 of this little card is about self-defense, and then you have just 1/3 of it, a line about international humanitarian law, the law of armed conflict, which is supposed to be the main framework regulating hostilities and the use of force in armed conflict situations. So based on this, I asked myself, why is this situation? Why are we so much referring to self-defense as a concept? If you look also at other stakeholders, not only states, but for instance, UN peacekeeping forces, in UN peacekeeping operations, self-defense is considered as one of the main principles. The reason for that is that when you have a true peacekeeping force under Chapter 6 or Chapter 6.5 of the UN Charter, these forces are not supposed to get involved into hostilities. So they may resort to force, but only as a last resort in self-defense. This concept of self-defense has nevertheless evolved also in peacekeeping missions, because it became clear in the 1970s that just having the opportunity to defend oneself or a unit would not be enough. And so defense of the mission has been included into the concept of self-defense for peacekeeping operations, which meant definitely that peacekeeping forces would more and more increasingly resemble peace enforcement forces, in particularly when they had tasks to protect humanitarian aid, for instance. PMSCs, private military and security companies, are also very much referring to the concept of self-defense. When they are not given the task to have law enforcement functions by a state, then the only option they have to resort to force, if they do not want to get involved into hostilities, is just to use force in self-defense. Even at the individual level, you can see that individual soldiers, when they are prosecuted for an excessive use of force in domestic jurisdictions, very often rely on self-defense. Take just one case, the Jalut case before the European Court of Human Rights, where a Dutch soldier who was in Iraq had an issue at a checkpoint. He used excessive force, and he relied on self-defense to say, well, you know, it was perfectly legitimate. It was a self-defense use of force. He did not rely on IHL. You can also look at a blog done by Henderson and Kavanagh on Opinio Juris, saying that many Australian soldiers are referring to self-defense in criminal law prosecutions to defend their use of force. So when we see this increasing reference to self-defense in armed conflicts, you have different views regarding that. A first view is that it's normal. Self-defense is central in armed conflict situations. This is a view that is particularly prominent in military spheres. Another view is to say, no, self-defense has no place whatsoever in armed conflict situations. In armed conflict situations, the use of force is regulated by the law of armed conflicts, by IHL, and self-defense cannot have a place there. So confronted with these various views, I have two objectives in my ongoing research project. The first objective is to try to understand what we are talking about when we talk about self-defense in armed conflict situations, so to clarify the notion of self-defense. My second objective is to devise recommendations based on an understanding whether it's a threat to refer to self-defense in armed conflicts or whether it's, on the contrary, an opportunity. So let's try to clarify a little bit just the legal sources of the concept of self-defense. We can say it's a multifaceted concept. The first legal basis can be found in the United Nations Charter under Article 51. It's the use ad bellum self-defense, national state self-defense. It has been defined by this article as an inherent right of individual or collective self-defense. It applies until the Security Council takes the necessary measures. Although in that provision you don't find the principles of necessity and proportionality, these are considered as belonging to customary law, as the ICJ has said, for instance, in the Nicaragua case. There are many contemporary issues related to use ad bellum self-defense. I will not dig into them, but I would just highlight two main problems which might be related to the topic we will discuss today. The first issue is the issue of temporality. Is it feasible to use force in self-defense when there is an imminent threat? I think now we are tending to go to the majority view saying, well, probably if the threat is imminent, it might be okay. But could, for instance, preemptive strikes be also accepted under that limb? That's another issue. So the temporality. Another issue is whether self-defense can be used against non-state actors. So like a terrorist group, is it enough that this group is committing acts which are akin to aggression to justify a use of force in self-defense, meaning that you will necessarily enter the territory of another state? And so it's linked with the unable and unwilling doctrine, etc. So these are two main issues. A third, more theoretical issue, which also appears when you look at Article 21 of the International Law Commission draft articles on state responsibility, is that in this ILC draft, self-defense is not portrayed as a right, but as a circumstance precluding wrongfulness, right? So here you see already theoretically we have an issue. Under the UN Charter, it's a primary norm, an exception to the prohibition on the use of force. In the ILC draft articles, it's a circumstance precluding wrongfulness. We are in secondary norms. So theoretically, we cannot even define the type of norms which are around self-defense. Another aspect of self-defense is what I would call human rights law self-defense. If you look at the ICCPR, Article 6, it prohibits arbitrary killings, arbitrary deprivations of life. So the word self-defense does not appear. But it becomes much clearer when you look, for instance, at the European Convention on Human Rights. In Article 2, which protects and guarantees the right to life, you see that one exception to the right to life is self-defense. It means that state agents, law enforcement officials, might use potentially lethal force, potentially deadly force, in order to protect their life, but also the life of others. Beware that very often for people, self-defense and law enforcement are almost the same. It's not. Self-defense is part of law enforcement, but as you can see in this Article 2.2, you have also other options for law enforcement officials. They can use force beyond just self-defense. They can use force to effect a lawful arrest, to prevent an escape, to quell a riot or an insurrection. Now you will tell me this is very regional. I would say no. It's not just the European Convention on Human Rights talking about self-defense in that kind of way. If you look at the UN Basic Principles on the Use of Force and Firearms, a soft law documents, you have a very similar definition of self-defense. So here, when we talk about self-defense under the human rights law limb, we also have the principles of necessity, proportionality, and imminence, which come back. But these principles, as we shall see, are not the same as under the use ad bellum. So here we are talking about absolute necessity. The use of force must be the ultima ratio. You must have avoided non-lethal use of force. Well, non-lethal use of force would not be able to reach the legitimate objectives you have, etc. You need to do a graduation of force. You need to have a strict proportionality. So it's a very, very restrictive regime. Under self-defense, it's even more restrictive because you really have the word imminence, which for Special Rapporteur Haynes means a matter of seconds, not hours. So it's now. That is imminence under human rights law self-defense. You have also the notion of self-defense even in international criminal law. I mean, if you look at Article 31, paragraph 1c of the ICC statutes, it says that you might refer to self-defense in order to defend yourself in cases of international crimes. Well, we will not dig into that because it opens a whole lot of other issues, but just to see that even at the international criminal law level, you have that concept. In international humanitarian law, my answer would be mainly not. I mean, there is no notion of self-defense as such, or at least it's mostly absent. You have some exceptions, though. For instance, regarding medical doctors in the armed forces, they cannot use force except in self-defense to protect their life or the lives of their patients. Some scholars argue that the concept of self-protection is not totally absent in IHL. For instance, Charles Kells is saying that the internal logic of LOAC rests upon a generalized notion of individual self-defense. But I would say that this is more on the philosophical aspect of it. It's not really the properly legal aspect of it. Criminal law. At the domestic level, obviously self-defense is a very important justification or excuse. Sometimes it's even portrayed as a right, even in domestic law, like in Switzerland. This defense or this justification or excuse is possible when you have a non-lawful attack, typically a use of force, when you respect the principles of necessity and proportionality, and you have also the option of defense of others. The main issue when you look at criminal law and self-defense is that self-defense is defined in very, very different ways depending on the states. Even in the US, if you look at the different states in the US, the definition of self-defense will be different. I've highlighted here two main differences. A first difference is that depending on the countries, you might use force in self-defense in order to protect property. This is the case, for instance, in many, in US, in many states. In Europe, it's more rarely the case to have defense of property. Then there is a notion of duty to retreat. Do you need to retreat if there is an imminent threat? You have another option. Is it part of necessity? Under a human rights logic, you would say yes. But under many domestic laws, it's not the case. So here you see also that criminal law is not always consonant with international human rights law. Finally, you have military concepts of self-defense. If you look, for instance, at the San Remo Manual handbook, or for instance, on the US Standing Rules of Engagement, you can see that self-defense is defined around three main concepts. You have national self-defense, like you said, bellum self-defense, personal individual self-defense, as the one you find in criminal law, and in between, a notion called unit self-defense, meaning that a military commander may decide to use force in order to defend his or her unit. In the US, it's even an obligation of the military commander. Here again, you have a problem of diversity. Depending on the countries, this notion of unit self-defense and these various notions, military notions of self-defense, will be defined in very different ways. You have also an issue of regarding legal basis. Regarding unit self-defense, not everyone agrees. Some people see unit self-defense as part of state self-defense, which in my view does not make total sense because, I mean, you don't need to wait for real aggression in order for a military commander to use force in unit self-defense. It can also be portrayed as a kind of defense of others, but it also raises issues because military commanders usually do much more in unit self-defense than what an individual like you and me could do in a criminal law context. And some others say it's a sui generis concept. It's maybe part of customary law, because if you look at rules of engagement in many countries, this notion of unit self-defense appears very frequently. Then you have the notions of hostile acts and hostile intents, which are related to the use of force in self-defense. But here again, countries do not agree on the exact definitions of those terms. For some European countries, it's not even part of self-defense. When you talk about hostile act or hostile intent, it's part of a mission accomplishment of a military unit, for instance. Another point of diversity that I've already touched upon a little bit is the legal characterization of self-defense. Some people talk about a right, others talk about a justification, excuse. At the international level, we have seen between the UN Charter and the draft ILC articles, there is not one answer, actually two different answers. Regarding human rights law self-defense, it has never been portrayed as a right. There is no human right to self-defense. It's an exception to the right to life, which is very different. So it can be seen as an exception, limitation to the right to life, but not so much portrayed as a human right to self-defense. In most domestic systems, it's a justification or an excuse, rarely a right. But in the rules of engagement, in general, you talk about an inherent right to self-defense. Some people say that it's even a general principle of law because you find it in many different domestic systems. Then the question of translation of this notion at the international level remains to be proved. But still, some, for instance, the ICTY in the Kordich and Cherkes case said it was a general principle of law. Now, to sum up on this first part, we can see that there are many commonalities between these various notions of self-defense. First, you need to have a non-lawful act. It could be a non-lawful attack or an aggression. Then you need to have this notion of imminence, at least if you accept it also in the sphere of jus ad bellum. You have the principles of necessity and proportionality, which are common to all definitions of self-defense, and finally, the possibility to intervene in favor of third persons. But don't be mistaken. It's not because we have those commonalities that it's the same concept. Actually, in my view, you have several self-defenses, not one self-defense. It's not only because it's at different levels. Jus ad bellum is about state self-defense. In rules of engagement, you talk about units. Personal self-defense is at the level of the individual. This is one difference. But you have also many other differences. If you look at each and every principle that is in the notion of self-defense, they are different. For instance, the trigger. For state self-defense, you need an aggression. Okay, we have no agreed upon definition of aggression, but look at Resolution 3314, dated 1974 of the UN General Assembly, and you can see that the severity, the scale of the aggression is huge. Obviously, at the individual level, there is no issue of aggression. It's a no-lawful act, a no-lawful attack. Also, the notion of imminence. Even if we accept the imminence notion, for instance, at the jus ad bellum, in the jus ad bellum aspect, imminence would not be a matter of seconds, not hours, for jus ad bellum, right? When you react to an aggression in jus ad bellum, it could take a few days, a few months, maybe. It might still be considered as imminent, or at least a few days. Regarding personal self-defense, that is not feasible. It must be really now. And the principles of necessity and proportionality also cannot be understood in the same way when you talk about jus ad bellum self-defense and personal self-defense. So having just one big definition of self-defense, which in my understanding is probably the case in the US, you will tell me if that's your understanding as well, is in my view confusing. I mean, it's not only different levels, it's different concepts of self-defense. Let's go now to the second part of my presentation. So the question is to see whether this notion of self-defense is relevant in armed conflict situations, whether it could lead to threats, different threats in armed conflict situations. Well, a third threat I would see is what I call the Babel Tower phenomenon. Everyone talks about self-defense, no one talks about the same thing. This will lead to many interoperability issues, in particular in multinational operations. And you can see military personnel explaining you that in military operations there are several rules of engagement explaining which country will do what activity because they have different notions of mission accomplishment, of self-defense, a number of caveats, etc. In my view, this from a humanitarian perspective is dangerous. I mean, if countries in a multinational operations do not agree on the main on one concept, which is self-defense, then it's an issue. It's also an issue regarding efficiency of those operations. Now, what could be the solution? Would it be to find a common ground, to find a single definition of self-defense, at least in military operations? I would say, in theory, yes, but is it really feasible? Do you really think that countries will agree upon a definition of self-defense when they have their criminal law, which is so different that they have applied for years and years? So probably that is not realistic. And so my question already here is, then why do we rely so much on self-defense? Why don't we rely on IHL, which is a concept of international law on which everyone has agreed? Okay, well, I'll come back to that later. A second problem is the probable conflation between jus ad bellum and jus in bello. This is not new. I mean, even the International Court of Justice made this conflation. If you look at the advisory opinion on nuclear weapons, you can see that the ICJ is saying that when maybe the survival of a state would be at stake, maybe it would be feasible to use nuclear weapons in self-defense. So here it's also troubling to see that the notion of survival of the state might justify maybe destroying humanity. So here it's clearly a conflation between jus ad bellum and jus in bello. But if we take maybe the US context, because we are in the US, we could take other examples regarding Israel, other countries, but we are in the US. So let's look at the Obama policy on drone strikes. Here, I think there is also a huge potential of conflation between jus ad bellum and jus in bello. I'm not the first one to say that. For instance, you can look at a very good article written by Jeff Korn in International Law Studies, who is talking about this conflation between jus ad bellum and jus in bello regarding the Obama policy. Let's take just this quotation. In the presidential policy guidance, it says, the term non-combatant does not include an individual who is targetable as part of a belligerent party to an armed conflict. Okay, that we can understand. Secondly, an individual who is taking a direct part in hostilities. Okay, second IHL concept, we understand. The two first define military objectives in IHL. Or an individual who is targetable in the exercise of national self-defense. So you have a third type of target based on national self-defense. This, from an IHL perspective, is very, very strange and difficultly acceptable. Another problem that is totally related to the first, but I've done two slides just to make sure it's clear. It's the concept of naked self-defense. It's a term that has been used by Kenneth Anderson, and I think this concept of self-defense is a slippery slope. So the underlying issue is the following question. Does every use of force against terrorist groups in self-defense amount to a non-international armed conflict? If I understand well the Obama policy, it would be or legal position, the answer to this question would be no. So you might have extraterritorial use of force, let's say drone strikes, in certain countries against terrorist groups, members of terrorist organizations, which would not amount to the threshold of a non-international armed conflict. And so in those situations, IHL would not be applicable. And so the Obama administration would answer, okay, in those cases, if IHL is not applicable, which is not the case in most drone strikes nowadays, but it could happen in the future, right? If IHL is not applicable, then regarding targeting, no problem. You apply self-defense rules regarding targeting. And those self-defense rules are also a conflation between jus ad bellum self-defense and human rights self-defense, right? It's a bit a mixture of both. So the consequence of that is that you have a disconnection between national self-defense and armed conflict situations. and that there is a total lack of clarity around the rules which would govern those kind of operations. As I said, I believe that in most drones operations today, in most of them you can connect them to an armed conflict situation where IHL would be applicable, and the Obama policy would be adding some self-defense criteria for policy reasons to IHL. But this concept of naked self-defense might allow in the future to actually use a war-type reaction to sporadic acts of violence, which is very worrying for our future. Another aspect, another threat, would be that self-defense is muddying the waters. So it's as if you had three paradigms governing the use of force in armed conflict situations. I know the conduct of hostilities paradigm, it's linked to IHL. I know the law enforcement paradigm, it's mainly linked to human rights law. But what about the self-defense paradigm regarding targeting? What's that? In my view, if you take at least an international law perspective and a state perspective, you don't have three paradigms, you have two. It's either conduct of hostilities under IHL, or the law enforcement paradigm, which applies at all times, including in armed conflict situations. Self-defense is not absent, but it is a subset of law enforcement, of the law enforcement paradigm. Again, I'm telling you, this is about states. I'm not talking about non-state actors. That will come later. Now, the interplay between the law enforcement and the conduct of hostilities paradigm is a topic which has been very much discussed. I worked on it a lot when I was legal advisor at the International Committee of the Red Cross. At that time, we had organized an expert meeting on the interplay between the two concepts, and we had produced for the ICSC this report on the use of force in armed conflicts, interplay between conduct of hostilities and law enforcement. So I will not dig into that now, but you can look at it for further information. Another threat is that you might also jeopardize IHL. Actually, we are replacing a stable, agreed-upon framework for the use of force in armed conflicts under IHL with an uncertain, multifaceted concept of self-defense. It implies also a total change of approach. The whole logic of LOAC, of IHL, is that you have a status-based targeting. You need to understand who is your enemy. Once you have identified a military objective, a target, you can engage that target. So everything is around defining the enemy, status-based targeting. Under self-defense, you forget about this notion of status-based. Everything is threat-based. If you see that there is a threat, you might use force in self-defense. But threat can be seen everywhere in an armed conflict situation. That's why the whole logic of IHL was not to rely on threat, but on status. Also, when you rely on status, it means that you will need to take precautions to verify that your target is a military objective, to protect the civilian population. All these notions of precautions somehow disappear, when not totally disappear, but are less crucial in self-defense operations, because it's the idea that it's a self-preservation, an urgency to use force. So the approach becomes totally different. Then you have also a potential of confusion around the principles of necessity, proportionality under these various legal frameworks. I mean, under jus ad bellum, what is necessary and proportionate is not the same at all as what is necessary and proportionate under IHL. So it's the same terms, but they do not have the same content at all. For instance, in jus ad bellum, the proportionality rule would say that you take all the measures which are proportionate to the attack with the aim to repel the attack. Under IHL, you need to compare the potential collateral damages with the concrete and direct military advantage of an attack. I mean, it's not the same concept at all. It's the same name, but not the same concept. Finally, self-defense versus direct participation in hostilities. If you look at the ICSC guidance on direct participation in hostilities, they say clearly that a use of force in self-defense, personal self-defense, is not direct participation in hostilities. Why? For instance, you are a civilian, you're attacked by a soldier. The soldier is committing a war crime, directly or intentionally attacking a civilian, you react by using force. This reaction has no belligerent nexus. You don't want to help your state against the enemy. You just want to preserve your own life, right? So there is no belligerent nexus. There is no unlawful attack. That's why it can be defined as self-defense. But some scholars have highlighted that in some situations it might be difficult to make just the distinction between self-defense and direct participation in hostilities. For instance, you had Lindsay Cameron and Vincent Chetaille wrote a book on PMSCs, private military and security companies, and they give the example of a PMSC personnel seeing a combatant being attacked by not being attacked. You see a perfidious act. So you see, let's say, someone who is pretending that he or she is a civilian and wounded, and the objective of that person, who is in reality a combatant, is to attack another combatant. So could the PMSC, seeing that there is this illegal, unlawful act under IHL, come in and protect the combatant against this unlawful act? That could be seen as self-defense, but at the same time, come on, it's direct participation in hostilities. There is a belligerent nexus. So here you see that sometimes it's not so easy to differentiate the two. Finally, I see in the threats a distortion and militarization of human rights law enforcement self-defense. The more we're using self-defense in a very lenient manner in armed conflict situations to adapt to military operation, the more the risk we have that in peacetime, self-defense concept will be influenced by this military practice. Look at the Ferguson events and about weapons, armed combat weapons that are used in law enforcement. We could do a parallel here. So it would not be about using combat weapons in law enforcement, but it would be using a concept of self-defense that is used in military context to do peaceful self-defense. I've talked a lot about threats. I think we need to recognize that there might be opportunities, or at least to ask ourselves whether there might be opportunities with that concept. A first opportunity would be to consider that jus ad bellum self-defense could limit the use of force by states, notably through the principle of proportionality. So here you have two views. The first view, in general, IHL experts would say, no, come on. The use of force is governed by IHL, it's conduct of hostilities. You don't look at jus ad bellum proportionality. And the other view would say, well, actually, maybe. If you look at what he's saying here, Professor Greenwood, who is a judge at the International Court of Justice, he says, as the ICJ recognized in the nuclear weapons opinions, the requirement that the force used in self-defense must be necessary and proportionate may have an impact upon which weapons and methods of warfare the state asserting the right of self-defense is entitled to employ. It may also affect the geographical scope of operations and other aspects of the conduct of hostilities. Professor Clapham, I had a conversation once with him, and he said, well, nobody takes into account this very important aspect of it. But it remains to be seen. So the may, what does that mean? To what extent this may have an impact? But it's true when you look at the nuclear weapons advisory opinion, and also in the oil platform case, the ICJ is going in that direction. But how far, it's really unclear. Another possible opportunity, it would be a further limitation on the use of force by states through human rights self-defense for policy reasons. For instance, during the expert meeting, the ICRC expert meeting on the interplay between the conduct of hostilities and law enforcement paradigms I referred to earlier, experts discuss various cases, notably the case, for instance, let's say the riot example. We not discuss the three of them, just the riot example. So you are in an armed conflict situation, a non-international armed conflict, an internal one. And you have a riot going on. In the middle of the crowd, you have fighters, insurgents, getting in and launching attacks. So at the same time, you have civilians committing acts of violence which do not amount to direct participation in hostilities, and fighters, insurgents in the crowd, using the riot just to launch really military operations. Soldiers confronted to that situation are in a very tricky situation. The majority of the experts which were convened by the ICSC agreed that the legal approach to that is to say that there is a parallel approach. The parallel approach means that against the fighters in the crowd, you might use the conduct of hostilities rules under IHL, and against the civilians who are committing violent acts not amounting to direct participation in hostilities, it's the law enforcement paradigm which applies. So two paradigms at the same time. Experts agreed on that, but at the same time they said, well, in practice, it's difficult. It's difficult to apply two paradigms at the same time for the same crowd. And some experts said, well, if you look at rules of engagement, very often for those type of situations, for policy reasons, you apply self-defense rules of engagement to the whole situation. So then you think, okay, is that a good option? So if it's self-defense rules of engagement, normally it should be even less than law enforcement. So it might be even more protective. So why not? I think that we can be open to that. But the problem is that there is no uniformity of the notion of self-defense. If you look at military concepts of self-defense in the US, I mean, hostile act, hostile intent means anticipatory self-defense. So here I'm not sure that it's really consonant with the law enforcement paradigm. You see what I mean? And more generally, for me, self-defense, when we talk about personal self-defense, it should be the same for law enforcement officials, soldiers, and for individuals. Can we, as individuals, manage a riot, man a checkpoint? No. These are law enforcement acts. It's broader than self-defense. So we are a little bit muddying the water by saying it's just self-defense. It's law enforcement, right? So I would be more comfortable saying, let's apply law enforcement rules paradigm to the whole situation. Now, a key point is that where I think there is a real relevance of self-defense in armed conflicts, it's when we talk about personal self-defense as a criminal justification. So let's imagine you are an individual, let's say either a combatant or a civilian in an armed conflict situation. You have used force in a certain context, in this context of armed conflict. Then you're facing trial. The question is, would you be able to refer to self-defense as a defense? And actually, I will not show that now. Maybe I can show it to you after during the Q&A because it's a long table. I have done the analysis for each and every situation. A combatant against another combatant, a combatant against a civilian directly participating in hostilities, a civilian against a combatant, etc. And I realized, I was astonished myself by doing this analysis, but I realized that in most cases, it's an option in a domestic trial to refer to the criminal defense of self-defense. The only real situation, or maybe not the only, but one clear situation where you couldn't, is when you have a combatant attacked by another privileged combatant. That's not an unlawful act. So here the first criterion of self-defense is not fulfilled. So here you cannot refer to self-defense, right? The only option is to refer to the authority you have under international humanitarian law. But even if you take a combatant who is attacked by a civilian directly participating in hostilities, you have clearly an authority under IHL to target that person. But at the same time, civilian DPHing could be considered from a domestic law perspective as an unlawful act. I'm not talking about international law perspective, but from a domestic law perspective. So you might even have the option to refer to self-defense as a justification or an excuse. I would say, don't go for it. Go for IHL, but it could be an alternative argument, right? So in most cases, it's not necessarily a must, but it's an option to refer to self-defense. Here, the problem I see is not so much that individuals can refer to self-defense as a justification when facing trial. The problem I see is that we are reversing the rule and the exception. That's an exception at the individual level. It cannot be a rule on how you conduct hostilities. It cannot be how you plan operations. It's just an individual option as a last resort in front of a judge. So saying that self-defense is not relevant at all in armed conflict would be wrong in my view because of that in particular. And because, as we said earlier, it's part of state self-defense, it's part of law enforcement for states. Another option I see is the use of force by non-state actors. Self-defense could be seen as filling the gap. Non-state actors are not directly bound by human rights law. At least that's the majority view. Some will disagree with that. There might be a trend to say that non-state actors have human rights responsibilities, that they are committing human rights abuses, but the majority view, at least among states, is that they are not directly bound by human rights law. So non-state actors, the problem is that in armed conflict situations, they are facing many situations which should not be under conduct of hostilities rules. Even think about the Islamic State. They're controlling huge parts of territories, right, of areas. So they need to somehow maintain law and order in those areas. They cannot conduct hostilities against the civilian population, but they want to maintain control over it. So saying that they're doing law enforcement is very tricky. Politically speaking, it's difficult to accept. So an option could be to say, let's derive those rules from self-defense. So self-defense could be seen as a kind of solution to fill the gap. To say it's not only conduct of hostilities, you also have this other paradigm of somehow usefulness of self-defense rules to maintain law and order. The alternatives would be to apply law enforcement type rules, mutatis mutandis, with the political problem I mentioned, or to consider that non-state actors are bound by human rights law, but I think we are not there yet, and that states are very reluctant to go as far as that. So that might be an option. I don't say it's the solution. I just say, maybe, let's think about it. So if I sum up, I would say that there are many threats related to the concept of self-defense in armed conflict situations. There may be opportunities, but the threats are prominent. So why there is such a heavy reliance on self-defense in contemporary armed conflicts? I see many reasons. First, it brings legitimacy. As soon as you say self-defense, it's like, okay, but that's fine. I mean, you were threatened, okay? So that's the first reaction. Second, it's to avoid complex IHL issues. It's true, I mean, IHL becomes increasingly complex regarding conflict classification, geographical scope of IHL, classification of individuals. So self-defense appears so easy. You just forget about those classifications. You just talk about a threat. You just need to define the threat. Moreover, it's not defined, so you have plenty of space to define it as you wish. It's a response to reality. I mean, it's not like during the Cold War where you expected Russians, armed forces coming, and you have two beautiful armies fighting maybe against each other with beautiful uniforms. I mean, this status-based approach becomes increasingly challenged nowadays, where your enemy is wearing civilian clothes. So it's a response to reality. Also because there is an increasing number of non-state actors implied in armed conflicts. UN peace forces, PMSCs, etc. I also see it as a willingness to have a mitigation of targeting. If you look at the Obama speech in Washington when the presidential policy guidance was just adopted, he was clearly saying that, well, in some cases, you might use force under IHL against non-state armed groups, but it shouldn't be the end of the story, and we should also have other additional criteria that should be taken into account, like imminence, etc., limiting casualties, etc. So those notions somehow are taken from human rights law and introduced in hostilities to mitigate targeting. I think that behind that there is also a positive reasoning, but my argument is that, okay, it might be nice in principle, but in practice, do we have more advantages or more challenges related to that? It's also linked with the idea that we need to provide a framework for targeting outside armed conflict situations, especially for countries like the US and Israel, which continue to negate the extraterritorial application of human rights law that has been accepted by most human rights bodies. So in conclusion, these are my take-home messages for you. The first one is that each notion of self-defense under jus ad bellum, IHL, and domestic law has its own meaning and principles. And so to have all-encompassing definitions of self-defense are misleading and dangerous. So normally when we talk about self-defense, we should each time say, I'm talking about jus ad bellum self-defense. I'm talking about personal self-defense. I'm talking about human rights self-defense. Second point is that we need to avoid at all costs conflations between jus ad bellum and jus in bello. This is one of the key tenets of IHL, and I think we should keep that in mind. Third aspect is that from a state perspective, there are just two relevant paradigms for the use of force. It's either the conduct of hostilities or law enforcement. Self-defense has a place under law enforcement, not as a third separate paradigm. Fourthly, from a non-state actor perspective, I think we can further explore the possibility to portray self-defense as an alternative to the conduct of hostilities in armed conflicts. And finally, from the perspective of individuals, I believe that self-defense, personal and defense of others, as a justification under criminal law remains highly relevant in armed conflict situations. But it shouldn't be seen as a way of planning operations. I thank you very much for your attention. Thank you.